friends. Today we are going to discuss about an important topic, mental health and matrimony. What are the questions, rights of persons with mental illness, and also the realities at this point of time. In this video, I'll be discussing how a mental health professional need to answer questions with regard to marriage of a person with mental illness. Let's dive into the topic. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be discussing specifically when a person with mental illness is getting married. There are certain questions that needs to be answered by a mental health professional who is treating a person with mental illness. I'll be answering 8 different questions in this video. Let's look into those questions. Should an individual with mental illness consider getting married? What is the likelihood of children born to a person with mental illness? The child will develop mental illness. What is the impact of psychotropic medication on childbearing and reproduction? Fourth question is, what precautions should be taken both before and after marriage in the context of person with mental illness? Should the prospective spouse be informed about the individual's existing or past mental illness? How should the process of disclosure, consent, and psychiatric evaluation be documented, and how to document that? What is the legal liability of the psychiatrist or the mental health professional if they provide wrong counseling or opinion regarding the marriage? What are the legal implications for the individual with mental illness and marriage? Let's understand about marriage. Marriage as an institution is the basic unit of our society. Invariably, it is said that family is often considered as the basic unit of the society and marriage as the foundation. Man being a social animal, including women, they are wired to be in a social situation, would like to have a partner, reproduce, procreate, and have a family. Mental illness is one of the partner having it may create a havoc in the family life if they don't take medication or if they are violent. Invariably, the marriage may break or they may end up in divorce. But one need to understand, mental illness can have a serious impact on marriage, but at the same time, a good supporting marriage can also provide a buffer and a resilience with regard to mental illness. Here, what I'm trying to say is, just because somebody has mental illness, they should not be allowed to marry is not the point here. Invariably, the prevalence of mental illness is around 10 to 15%. That means, invariably, those marriages either need to be nullified or divorced. Is it that what I'm telling? No. Here, just because somebody has mental illness does not mean that the marriage is not on the cards. However, with adequate awareness about the mental illness, being adhered to the medication, adequate support from the spouse and the family members, they can have a fulfilling family relationship. Invariably, the trust and understanding is the crux of the marriage. Hence, the person with mental illness should be aware of their roles and responsibility about the marriage. And at the same time, in many communities, they believe the marriage cures mental illness. That's completely a myth. That means, just because somebody has mental illness, don't get him married. That marriage will end up in divorce. And marriage is not the treatment for mental illness that every person in the society should know. Let's move to the first question. Should individuals with mental illness consider getting married? Mental illness is not a barrier or a contraindication for marriage. Every citizen has right to get married, provided the other person who is getting married should know. Mental illness, like any other chronic conditions like diabetes, hypertension, psoriasis, or any other physical illness, they can get married. That means mental illness does not mean that marriage is prohibited. If a person with mental illness is clinically stable, taking medicine, and is able to give consent for marriage, and also he knows the roles and responsibility and obligation of the marriage, then he can get married. Invariably, the marriage is a personal decision. However, in India, the decision is a shared decision making in most of the marriage. That is, both the families, that is, the bride and the bridegroom family, have to give consent with regard to marriage. Although the primary is between the bride and bridegroom, it is the two families who take decision. Here, the role of mental health professional is to facilitate the decision making, whether to go ahead with the marriage or not with the marriage. It is not either advocating or prohibiting marriage. If you look at the law, Hindu Marriage Act, Section 5, subsection 2A clearly says that the incapable of giving a valid consent by the person with unsoundness of mind, the marriage will be considered as invalid or null and void. Though he is capable of giving consent, but suffering from mental illness of such a kind to such an extent is unfit for marriage or the procreation of the children. This subsection 2B, although he is able to give consent, he has a capacity to consent, but his mental illness is such a degree, he is unable to procreate, that is basically reproduce, and he is unfit for the marriage. This is a very, very broad definition given by the Parliament, both in the Hindu Marriage Act and Special Marriage Act. However, based on the case-by-case basis, the Supreme Court has decided the cases. Further, it also says that, or if the person is having recurrent attacks of mental illness or insanity, it says. What does that recurrent attacks? It has not been defined. It is based upon the severity of illness. That's how we can interpret. So this is how the Hindu Marriage Act talks about mental illness and marriage. If you look at the landmark decision, one is Ram Narayan Gupta versus Srimati Rameshwari, decided in 1988 by the Supreme Court of India. It said very clearly, mere branding of a person as schizophrenia will not be sufficient for the purpose of section 13(1), subsection 3. It is the act of schizophrenia, what schizophrenia does to a patient, that determines the divorce. That means just because somebody is mentally ill does not mean it prohibits marriage. This clearly determines that the degree of severity of mental illness, which determines degree of divorce. That means invariably it has to be severe illness, then only the divorce will be granted. Another landmark judgment is Kollam Chandra versus Kollam Padma, decided in 2013 by Supreme Court of India. Even in that case, it also said that it is not the diagnosis of mental illness, it is the severity, and is unable to perform the obligations of the marriage. That's what the wording or the summary of the decision of the Supreme Court. That means even the Supreme Court has interpreted the Hindu Marriage Act and Special Marriage Act is that it is not the diagnosis which decides the divorce, it is the severity of the illness. So, in simple words, if a person with mental illness is getting married, he should be reasonably symptom free, at least for a few months, and he is doing well. He is able to take the responsibility of the marriage. He is able to give consent for the marriage. He has insight about his illness. He is ready to take treatment, and he knows the obligations of the marriage, that is roles and responsibility in marriage, and he knows the early signs of relapse. And if there are no side effects with medication, especially sexual side effects, then he can get married, but he need to inform the prospective spouse. That's the crux of this point. The second question: what is the likelihood of children born for a person with mental illness develop a mental illness again? That means if either the father or the mother has mental illness, what are the chances the child develops mental illness? The likelihood of children born to a parent with a mental illness, when compared to general population, the likelihood risk is high. The risk increases from 2 to 4 times higher than the general population. In general population, for severe mental disorder, it is hardly 1 to 2%. If one of the family member, that is the father or the mother, has mental illness, the risk increases by 2 to 4 times. If you look at the schizophrenia, the lifetime risk is 1%. If one of the family member, either the father or the mother, has mental illness, it increases tenfold. If both the parents, that is the husband and the wife, have mental illness, the children can have 40% increased risk of developing mental illness. Similarly, in bipolar disorder, the risk increases by 2 to 20%, my dear friends. That means we need to explain the prospective spouse that there is a possibility the child may develop. That means risk does not mean destiny, but this is the probable risk, has to be explained. If you look at the studies, it suggests that 50% of the children born to a person with mental illness may have one or the other form of mild mental illness. So these factors which increases the likelihood of mental illness is genetic factors or the genetic loading, consanguinity in marriage, types of mental illness, environmental factors, substance use, childhood trauma. That means both genetic and environmental factors play a crucial role. However, there are protective factors also: a good supportive environment, regular treatment, adherence to medication, staying away from drugs, regular sleep habits improves the possibility or decreases the possibility of developing mental illness. That means you may have to give the information in such a way that yes, if a person with mental illness is getting married, the chances of child developing mental illness will be between 20%. That may be the best way to put across. So the probability wise, you can say that if 100 people with mental illness get married, 20 children may develop mental illness. That means if they have child, 20 child may develop illness. The remaining 80 may not. That just because somebody has mental illness does not mean it is a destiny that the child also will develop mental illness. No, it is only 20 to 30%. If both the people has one or the other mental illness, the risk doubles. That is around 40%, we can tell. Now the question is, what is the impact of psychotropic medication on childbearing and reproduction? So here, if a person is doing well, but he is on medication, what are the issues which can develop? Based upon the psychotropic medication or the psychiatric medication, the fetal exposure, was it in the first trimester, second trimester, or the third trimester? Was it a planned pregnancy, unplanned pregnancy? These play a crucial role. Based upon the medication, if the person is on valproate, the possibility of neural tube defect is there. If it is on lithium, cardiac abnormalities possibility. SSRI is relatively safe, but there is a possibility of withdrawal symptoms. Hence, before planning pregnancy, it has to be discussed with the psychiatrist, switching to a safer medication, whether they can stop the medicine, drug holiday to be considered. That decision need to be taken by the couple. However, if a woman with mental illness is on medication, is there a possibility of avoiding psychotropic medication exposure in the first and second trimester should be discussed. If they are on medication and it is an accidental pregnancy or it is a planned pregnancy, closed monitoring of the pregnancy to be done. Ultrasound of the abdomen should be done frequently as possible. Blood testing for teratogenicity has to be considered. And one need to liaison with the obstetrician with regard to it, maybe for contraception or planning pregnancy and the delivery of the child. If there is any signs of malformation, fetal malformation, MTP can be considered within 20 weeks. Liaising with the neonatologist is also essential. Immediately after the birth, if there are any withdrawal symptoms, need to be addressed immediately. And also psychiatrists should look for signs of relapse and start medication or monitor the medication. With regard to men having mental illness and on medication, invariably sexual side effects may come in the way of marriage consummation or having a baby. That means sexual side effects need to be treated. And men being on medication, what is the effect of teratogenicity? At present, we do not have convincing evidence. And the science has not progressed to that level. If the man is on psychotropic medication, what is the impact on the child because of medication? We don't know. Now let's look into what precautions should be taken both before and after marriage in the context of person with mental illness. If a person with mental illness is getting married, he needs to discuss with the treating psychiatrist. A thorough psychiatric evaluation should be done. Whether he has a capacity to consent, whether he has symptoms free, whether he is doing well, whether he is able to understand the roles and responsibility of the marriage, whether he is functional, whether he is able to earn money. If it is a female, whether she is able to take the responsibility of marriage like cooking, taking care of the household chorus, or if she is able to work, whether they are able to cope with the stress of marriage, and they know about the early signs of relapse. Above all this, if a person has good insight and takes the responsibility of taking medication and does well on medication, then before marriage, these factors play a crucial role. And the psychiatrist should clearly say that during marriage it is highly stressful. They should not stop medication. Many of the cases in the Supreme Court where nullity was granted, there the relapse had occurred immediately after the marriage. That means many of these people stop medication either before the marriage or after the marriage and the relapse. This leads to either nullity of marriage or maybe divorce later. Hence, this factors to being on medication during marriage is very essential, and if they are stressful, then the dosage may be increased. After marriage, treatment adherence is very essential. Spousal support, coming for frequent follow-up, planning contraception, both taking a responsibility of marriage, able to cope with the stress of the marriage, regular sleep habits, avoiding substance use, and also family support from 360 degrees, very essential to the couple. So these are very essential. Things need to be known, both the parties who are getting married. Next important question is, should the prospective spouse to be informed about the mental illness? This is a very controversial point, but as a professional, we need to take a stand. We need to discuss pros and cons of disclosure with the patient and patient's family member. Many a time, the patient and patient family member may not disclose the marriage either to the treating team or to the psychiatrist or to the opposite party. In such a scenario, the psychiatrist or the treating professionals may be kept in the dark. That we can't do anything. If they are discussing about marriage, the mental health professional should offer support for facilitating disclosure. And if the patient consents, a joint session can be held between the two families. Hence, a premarital counseling between both the parties is essential. And that should be offered by the psychiatrist and any other mental health professional. Here, the transparency should be encouraged because marriage is built on trust. And I'll be discussing about the legal implication for not disclosing shortly. Emphasis should be on disclosure about the mental illness. And if you look at the Hindu Marriage Act, Section 12C clearly says that the consent of the petitioner or the person who is getting married, if it is obtained by force or by a fraud, to the nature of the ceremony or as to any material fact circumstances concerning the respondent. That means if a person is kept in the dark or the disclosure of mental illness is not done and it is a severe mental illness, nullity of marriage can be granted. For simple reason, the marriage is built on trust, hence the disclosure should be there. And the families of person with mental illness and the person with mental illness should be told. There are various cases in the court of law where the annulment has been given and some cases divorce also has been given. Hence, disclosure should be there and it should be occur before the marriage, not at the last minute during the marriage. That means sufficient time should be given, specifically in India, before the marriage, the engagement takes place. Before the engagement, the disclosure should be done. That is, before the wedding card is printed, before the publicizing about the marriage, the disclosure should occur. It is not at the nth minute. On the day of marriage, if you disclose, it will be very difficult to take a decision. Hence, a sufficient time should be given regarding the information. That has to be emphasized to the person with mental illness and the family members. Disclosure should be between the significant people involved in the marriage, that is, the bride and the bridegroom, and of course, their parents and the siblings who are involved in the marriage. And the disclosure should be with regard to need basis, not a exhaustive disclosure need not be required. And this disclosure should be done by the patient and the patient family members. The mental health professional should facilitate. Here, the mental health professional should not go and disclose to everyone this person is getting married. That can be a violation of right to confidentiality under the Mental Health Care Act of 2017. Hence, before disclosure, and the psychiatrist is involved in the counseling, he needs to take a written informed consent from the patient telling that we are going to discuss with the patient and the patient's spouse, that or the prospective spouse. That has to be documented. In the Supreme Court decision, Shravan Jha versus Kiran Kumari, the Jharkhand High Court in 2016 categorically talked about the non-disclosure. Here, the husband had a bipolar disorder and it was not disclosed during the marriage. And in this case, the nullity of the marriage was given. Then that means the family court and also the High Court of Jharkhand clearly said that the fact that was required to be provided is the consent obtained by practicing fraud. That is not providing the information of mental illness, and by suppressing the material fact of mental illness has to be proved. And here the petitioner, that the wife was able to prove that he had mental illness and within few days of marriage he had a relapse. In this case, the Jharkhand High Court was categorical. It said that yes, the wife should be given degree of nullity, and also the Shridan, whatever 5 lakhs was given, should be returned back to the wife. So, my dear friend, the Supreme Court, the Jharkhand High Court was very categorical. Similarly, in another important case, Alka Sharma versus Chandra Sharma, Madhya Pradesh High Court. In this case, the wife had mental illness. The Abhinesh Sharma was given the nullity of marriage. Again, the relapse occurred within few days of marriage. So, disclosure is mandatory, my dear friends. Now the question comes, how to document the process of disclosure? Whether the mental health professional should be involved or not. This is an important question we need to answer. The mental health professional has a duty to discuss about the marriage and the implication and how the disclosure should be done. Before the disclosure occurs, both the prospective spouse and his family, patient and his family members, significant people, are called. The consent of the person with mental illness has to be taken. It should be written. Date, time, and duration of counseling occurred. People involved in the discussion should be named and how they are related in this marriage. What are the questions asked by the patient's side and the prospective spouse and their family members? What questions were asked and how the answer was given? Invariably, certain questions need to be answered by the person with mental illness, and they should start the discussion telling that, yes, I so and so has been diagnosed as bipolar disorder, now on medication, doing well. What are the questions you would like to ask? I would like to answer. And any doubts, the evidence based answers will be given by the doctor. That means you are a facilitator. As a mental health professional, you are not going to take the first step. Your job is to facilitate disclosure and providing evidence based information. And the discussion should occur in the presence of persons with mental illness. It's not that separately doing discussion. And education materials, what shared, if you may have given the books or maybe pamphlets or maybe website, needs to be documented in the file, summarize the discussion in the medical record, and you may require 1 or 2 sessions, and they may be called after a few days to discuss, and you need to communicate the documentation. I have done the documentation regarding this session. This is very essential. But however, please remember, as a mental health professional, you are neither going to coerce somebody to get married or prohibit marriage. Here, you are sitting here as a facilitator to take decision. Whatever the decision, both the parties will take. Your job is to provide information, not pursuing somebody to get married or prohibit somebody to get married. Now, what are the legal liability of a psychiatrist if the marriage turns or something goes wrong in the marriage? What will happen? That is the reason I told. The psychiatrist and the mental health professional should not advise for marriage or advise against marriage as a perspective, or you should not say that, yes, you should get married or you should not get married. No, it is an individual decision. Here, the mental health professional facilitate their decision making. It is their personal decision. I'm emphasizing this very important word. Decision to marry or not to marry is a personal decision between the two parties. Hence, avoiding this prescription, coercion, persuasion, or recommendation should be avoided by the mental health professional. Provide a psychiatric diagnosis, current status, improvement, prognosis, and whatever the questions they are asking. That is the role of mental health professional. Do not get involved either the patient side or the patient's spouse side. You have to be neutral, provide information. It is their individual decision. You are not here to advocate or prohibit. What are the legal implications for the individuals with mental illness after marriage? Here, as I mentioned earlier, before the marriage, sufficient time has to be given for the disclosure if it is a severe mental disorder. Even if the person had a mental illness around 3 or 4 years back, which was severe in nature, which was disabling, and he has recovered, it is best to disclose. Because disclosure relies on the trust. The marriage relies on the trust. By disclosing, they can take a informed decision making. Of course, they may reject the alliance, but imagine if it goes to divorce or nullity of marriage after the marriage, the hardship both the families go through is enormous. The amount of money lost in a marriage, and also having the divorcee or knowing about the mental illness by everybody will have a lot of stigma. Hence, the pros and cons of disclosing, not disclosing, the repercussions to be discussed with the patient and the patient family members, and it is their decision. But we are here to facilitate disclosure and emphasize there is a need for disclosure. The law mandates that disclosure is essential. And also emphasize, diagnosis of mental illness does not equate divorce. It is the severity of the mental illness, recurrence of mental illness or recurrent attacks of mental illness, unable to procreate because of mental illness. All these will play a role in divorce. And you also have to mention, mental illness should be of such a kind and that person should be unfit for marriage and procreation. That is the word used in the Hindu Marriage Act and Special Marriage Act. That should be clearly told to the patient and the patient family members. Further, you need to also discuss about the divorce. A divorce can be granted if a spouse has an incurable unsoundness of mind. That is the word used here, incurable mental illness. That means the person has a severe mental illness which is resistant, unable to carry the obligation of marriage, and there is a recurrent attack of mental illness and has been suffering from mental disorder to such a extent or such a uh, severity, the other spouse cannot reasonably be expected to live with the person. That either one of the criteria meets, then the person gets a divorce from a person with mental illness. Hence, as a mental health professional, we need to advocate for having a good medication adherence, family support, and disclosure. However, psychopathic personality can be considered as a divorce. Cruelty in marriage. Imagine a person with mental illness, paranoid schizophrenia, drug abuse, alcohol use. He is beating his wife very badly. Violence is there in the marriage. Suicidal threats, physical violence. These can be a ground for divorce, and it is be considered as a cruelty in marriage. And if it is for mental illness, yes, of course. And if it is occurring very recurrently or recurrent episodes are there, then the possibility of divorce can be given. Further, the custody of the child. Imagine a person with mental illness is married and has a child. Now the issue, the divorce has occurred, the custody of the child. It is also based upon the severity of the symptom, disability, able to take the responsibility of the child, what is the best interest of the child. All these will be taken into consideration before the court comes to the decision. Hence, my dear friends, as a mental health professional, you need to be very careful when you are doing counseling. Do not take side, facilitate disclosure. You are here to facilitate the decision making. To summarize, my dear friends, marriage is possible in a person with mental illness. Adequate planning, adequate support, good treatment adherence, having good insight, having a recovery, that person can go into marriage. But as a psychiatrist or a mental health professional, should not advise or should not advise against the marriage. You are here to facilitate decision making for both the parties. However, please remember, emphasize on disclosure with regard to mental illness, because it's not only ethical and it can be a legal issue if it goes for nullification or null and void marriage, or it can be a divorce. Hence, continuous support is required. Being on regular medication, being on regular follow-ups helps. I have many patients who are married, who are doing well, but at the same time, there are few patients who are having poor insight, stop medication, their marriage either have been divorced or they are living separately. So, this is what a mental health professional should know about marriage of a person with mental illness. Thank you very much for your kind time. Stay safe.